I want to talk about the use of history in general. I should start by making a few preliminary comments. First of all, I am mostly agnostic about firearms regulation. I can take the McCarthy era oath. I have not now nor ever have been a member of any organization that advocates for or against gun control. I have never taken a nickel from any organization for or against gun control. And so I come as a historian. I'm a historian who taught in law schools for about 20 years. I have been cited by the court a number of times, including in the McDonald case. I have written more law review articles than any sane human being should ever write. And now these law review students want me to continue to be insane and do another one. But I'm coming here as an academic, not as somebody who is involved in policy debates. I grew up in upstate New York. I love venison. I always loved it when my friends brought deer home because I would get some. If any of you are hunters, I still own a house in Albany County, and I would be delighted if you'd come to my backyard and save my hostas from the deer during hunting season. That would be really helpful to me. And in fact, I am a firm believer in having more hunters in America. Since we have killed all of the natural predators of deer, except for automobiles, we need more hunters to actually regulate the environment. So let me start with that. The second thing I want to make is that the Second Amendment, despite what some passionate advocates say here, was not written about the right to own firearms or the right to bear firearms in an individual capacity. All of the debate in the constitutional period, from the writing of the Constitution through the ratification, through the Bill of Rights, all of the debate that has any meaning, that has any substantive end, is about militias. Now, there are plenty of anti-federalists who come forward and say, we would like a personal right to own arms. If you want to see the high point of anti-federalism, you can read, and I will quote from it if I have time in this very short talk, the reasons for the dissent of the Pennsylvania minority. These were a group of disgruntled Pennsylvanians who had been outvoted 2-1 in the Pennsylvania ratifying convention. They had been slaughtered in the ratifying convention, and after the convention was over, they went to a bar and they wrote up a list of complaints which became the demand for their Bill of Rights. In that, they have a number of personal rights claims. They want, for example, the right to go hunting. They want to go fowling, as they call it, which is shooting birds. They want a federal constitutional Bill of Rights to protect their right to go fishing. Had these people won, we would have no environmental regulations in the United States today. And there could probably be no, at least at the federal level, regulations about when you can hunt, because these guys wanted to do it all the time. They also offered a number of other important provisions for fundamental liberty. Language of the First, Third, Fourth, Fifth, and Sixth Amendments are found in the reasons for dissent. And when James Madison wrote what becomes the Bill of Rights, the 12 amendments, by the way, the second is actually the fourth when he sends it to the states. When he wrote what becomes the Bill of Rights, James Madison had before him what the Pennsylvania minority did. And if you look at the text and you actually do the research, something that Justice Scalia never was very big on, what you will find is that Madison uses much of the language of the Pennsylvania minority in the First, Third, Fourth, Fifth, and Sixth Amendments. And he ignores their 4 separate provisions on hunting and fishing and fowling and owning weapons. So if you want to talk about originalism, if you want to talk about what is going on in the First Congress, this is the place you have to look. You cannot look to the 17th century debates in England over the militia. I mean, it's useful. It helps us understand what some people in the United States brought to the table. And ultimately, you cannot look at the anti-federalists. Why? Because although there are many people in this room who have a fantasy about the anti-federalists, they love the anti-federalists. The anti-federalists are the great icons of fundamental liberty, so they think. They need to understand the anti-federalists are the greatest losers in American history. They opposed the Constitution in 13 states. And in every one of those 13 states, they either got their rear end kicked or their head handed to them, or both. They lost in every one of the 13 states. And that tells us something about how valuable the anti-federalist arguments are. They are interesting, they are fun. Some of them lead to some of the amendments that we have in the Bill of Rights. But when Madison writes the Bill of Rights, he is very clear that he is not going to do anything to undermine the fundamental new Constitution. He's not going to undermine the power of the new national government. So when people talk about, well, the Second Amendment is there so people can have a right of revolution, keep in mind, the Constitution is written after Shays' Rebellion, right? Shays' Rebellion is a disgruntled group of farmers and former revolutionary soldiers, what we would call the unorganized militia, or simply the rabble. And the Constitution is written to make sure that the national government can prevent the rabble from doing what it did in Massachusetts, which is to seize a bunch of courthouses and shoot up a bunch of people, and a few people get killed. This is what the Constitutional Convention wants to prevent, and this is what the first Congress wants to prevent. And remember, when you look at the makeup of the first Congress, with the exception of the 2 senators from Virginia, everybody in the Senate is a Federalist, a supporter of the new Constitution, and about 95% of everybody in the House of Representatives is a Federalist, a supporter of the new Constitution. Now, you have to understand there's a difference between a Federalist at this time and later the Federalist Party, which is the party of major Broadway plays today. But you have to understand that the Federalist in 1787 through 1791 is somebody who supports this new Constitution. The Congress is overwhelmingly Federalist. It's also worth remembering that Madison didn't even think we needed a Bill of Rights. He says so over and over again. When you see what he says when he introduces it, he says, we don't need it, but it won't hurt anything. He writes to Edmund Randolph, who had refused to sign the Constitution but later becomes a Federalist and supports it. He writes to Edmund Randolph that he's done nothing to harm the power of the national government. So when you talk about the Second Amendment as being this amendment which allows any yahoo anywhere to pick up a gun and confront the government, you have to ask yourself, is this what people froze their butts off at Valley Forge for? Is this what the Constitutional Convention was all about? Is this why all across the continent everybody was scared of Shays' Rebellion? Because there was no army, there was no national government to suppress this kind of rebellion. Now, some of you are going to say, but wait a minute, we're a revolutionary country, right? Declaration of Independence. Well, okay, the Declaration of Independence, written by Mr. Jefferson, by the way, again, remember, he's not around for the Constitutional Convention, and he's barely around for the writing of the Bill of Rights. He's in France, on his way back with Sally, and he's not involved in any of this process. But the Declaration of Independence sets out a process by which you have a right of revolution. It says governments are instituted among men, deriving their just powers from the consent of the governed. And when the government ceases to do that, then the people have a right of rebellion. But everybody in Congress, even the anti-federalists in Congress, would say that you don't need a right of rebellion in the United States because we are a democratic republic. That is, we are a representative government where the people are electing the government. And therefore, you don't have to prepare for the eventuality that you're going to have to take up arms against the United States. So that's the first set of principles to think about. Tied to this is, of course, the fact, and I'm fascinated by Second Amendment debates because nobody ever reads Article 1 of the Constitution. They all talk about the Second Amendment as though it sits there all by itself in the middle of nowhere, disconnected to everything else. But what's important to understand is that Article 1 of the Constitution, I'm sorry for reading, but I, like Justice Black, I want to have the text exactly right. It gives Congress the power to declare war, to raise and support armies, to maintain a navy, to make rules and regulation, rules for the government and regulation of the land and naval forces, to provide for the calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, and to further provide further to provide for organizing, arming, and disciplining the militia. There are other militia clauses as well. The president is ultimately the commander-in-chief of all of the militias. So why do we have a Second Amendment? Because some anti-federalists are fearful that some tyrannical president, an American Caesar, combined with that oligarchy, the Senate, and by the way, who elected the Senate in those days? The state legislatures, right? Not the people. But somehow, all of the state legislatures were going to send these crazy oligarchs to the Senate, and between the Senate and the president, they were going to take over the government, create a military dictatorship, and not arm the militias, as the Constitution says. And so when the Second Amendment comes to the House, or when the Bill of Rights is being discussed in the House, Madison says, look, if you people want a guarantee that you can arm your militias, no problem. I'll give it to you. Note, by the way, the text of the amendment. A well-regulated militia being necessary to the security of a free state. There is no other amendment to the Constitution that has an explanatory clause. Imagine what the First Amendment would be like if it said, in order to have a Republican form of government with democratic elections, we must have free speech. Then we would know that free speech is about political speech. And those of us who advocate cultural speech, those of us who advocate artistic speech, those people who like to watch dirty movies, they would be out of luck unless you can somehow hammer art and culture and music and literature into politics. But the framers of the First Amendment don't say that. They simply say, Congress shall make no law, ... and then we get our protections. Only in the Second Amendment does Madison think it's important to remind everybody what the Second Amendment is about. Now, another problem with the use of history, and this came up last night in the panel about whether or not just anybody can be a historian, because after all, we live in a world where we don't believe in credentialing, right? We should get rid of the bar exam, get rid of law schools, get rid of medical schools, get rid of medical licenses, get rid of dentistry licenses, because after all, any person can simply hang out a shingle and say, this is what I do. And so anyone without any training in history, without any reading in the vast secondary sources of a field, without understanding how to use primary sources, can simply assert, well, I can write history as well as the next person. And so we get kind of weird history. For example, one Second Amendment scholar, an attorney who is not a historian as far as I know, decided that the Second Amendment meant you had a right to carry a pistol because, he wrote, he looked up the term bear arms in a dictionary and found that a bear arms meant to bear arms as in a coat.
Oh, please.
In other words, Stephen Halbrook does not know the difference between sticking a pistol in your belt and a coat of arms. And so he took this dictionary and he said, aha, bear arms in a coat means you can only carry a pistol because that's what bearing arms mean. But of course, this was about a coat of arms. So what we have are people who pretend to be writing history, who in fact often distort the history, perhaps not intentionally. I'm not accusing people of intentionally doing this. What I'm suggesting is that if you're not doing history in a serious way, you're going to get some really weird results. Let me give you another example. A number of scholars who favor the NRA's view of the Second Amendment often cite a letter that Thomas Jefferson writes to George Washington. And in that letter, Jefferson says that he does not like to go about without being armed. And so a number of people have used this letter to show that Thomas Jefferson believes in the personal right to bear arms. The only problem is the whole letter is about a package of letters that Washington has in his possession that Jefferson sent to Washington when he was president. And Jefferson wants the letters back because he's going to be in a debate. And so Jefferson says, and again, let me just read from the text here so I get it exactly right. He is writing Washington asking for copies of some old letters to have handy so he could issue a rebuttal in case he got attacked for a decision he had made as Secretary of State. The ammunition Jefferson wanted so that he could be, quote, armed, because that's what he was talking about in his letter, is in the form of written documents. As the historian David Koenig had written, unfortunately, and in this case he's referring to the scholarship of a Second Amendment scholar named Cates. Unfortunately for Cates, Jefferson was not writing about firearms. Rather, he was asking Washington to return to him a document on a diplomatic matter that Jefferson had given to Washington and which he might need in the future. Though I do not know that it will ever be of the least importance to me, he says in the letter, yet one loves to possess arms, though they hope never to have the occasion to use them. This is not about guns, but if you extract from historical documents, if you rummage around in documents without any understanding of the past, without any understanding of context, then you get to Thomas Jefferson asking for a package of letters as proof that Thomas Jefferson believes everyone should go about being armed. So this is one of the problems that we have with the whole Second Amendment issue. That people are not looking at texts, and they are not looking at texts in their context. Again, to go back to the Pennsylvania dissenters, I have read in a number of articles how the demands of the Pennsylvania dissenters show that the Second Amendment is about a personal right. And so the Pennsylvania dissenters say that they want a right to bear arms for the defense of themselves and their own state and for the purpose of killing games. They want the inhabitants to have the liberty to fowl and hunt in seasonable times, etc., etc. The only problem with this is that Madison doesn't use this language. He ignores all these provisions when he writes the Bill of Rights. Now, as a historian, you can't do that. You can't say that a document which is not used, which is clearly rejected, and we know, by the way, that Madison has the document in front of him because he's using other language word for word on things like the Fifth Amendment. You can't say that this is dispositive of what the document is all about. This is not how historians operate. So with that in mind, let me turn to one final statement from Madison, and then I want to turn to Justice Scalia's opinion. So Madison, when he's drafting the Bill of Rights, writes to Edmund Randolph, and he says, in a private letter, the structure and the stamina of the government were as little touched as possible. And what he means by that, of course, is the national government will have the structure and the stamina to suppress the next Shays Rebellion, the Whiskey Rebellion, other rebellions, including, by the way, the one that begins in South Carolina in early 1861. And if we imagine the Second Amendment of the Pennsylvania dissenters, it would have perhaps been impossible for the national government to do that. But think about what the national government is worried about. It's worried about Indians. It's worried about whites selling guns to Indians. You don't think that the national government wanted to preserve the right to prevent traders from taking guns out to the Indians so the Indians could make war on the United States. You don't think the national government wanted to prevent people from giving arms to slaves. Quite the contrary. They are creating a government to exist for the ages. And so let me turn briefly, because I think I'm going to run out of time in a couple of minutes, to the Heller decision. Because in the Heller decision, we see some very weird language from Justice Scalia. Justice Scalia wants to use contemporary state constitutional amendments to explain the Bill of Rights, to explain the Second Amendment. So he quotes the Pennsylvania Declaration of Rights, that the people shall have a right to bear arms for the defense of themselves and the state. However, and I wonder what he would have done if he had been Professor Scalia, as he once was, and somebody turned in a paper that did this. Because actually what the Pennsylvania Constitution says is the people shall have a right to bear arms for themselves and the state, and as standing armies in time of peace are dangerous to liberty, they ought not to be kept up, and that the military should be kept under strict subordination to and governed by the civil power. What is this about? It is about the well-regulated militia. It is not about personal ownerships, or at least it is about both. But Justice Scalia doesn't give us the whole clause. He truncates it because he doesn't want us to know that the main clause in Pennsylvania is about this. He then quotes the Vermont Constitution, again saying it's contemporaneous. The only problem is Vermont isn't a state. So I wonder if any lawyer went to the Supreme Court and said, Your Honors, you should follow the precedent of this non-state, this non-entity, this putative state, this revolutionary group in Vermont, because they want to be a state someday. So we should use their proto-constitution as a way of understanding what James Madison is writing in 1789. I assume that in normal circumstances, Justice Scalia, along with the rest of the court, would have laughed at that argument. But in Heller, suddenly the Vermont Constitution is there. He also quotes the North Carolina Constitution, which is really interesting, because the North Carolina Constitution says the people have a right to bear arms for the defense of the state. Now, this is not a personal right. This is for the defense of the state. But Scalia admits this could plausibly be read to support only a right to bear arms for the militia, and then declares, but this is a peculiar way to make the point. Quite the contrary, it seems to be a very obvious way to make the point, unless, of course, you don't like the point that it's making. And again, Justice Scalia would have been more honest. Dare I suggest the deceased member of the court is less than honest if he had given us the whole North Carolina clause, which says the right of the people to bear arms for the defense of the state, and as standing armies in time of peace are dangerous to liberty, they ought not to be kept up, and the military should be kept under strict subordination and governed by the civil power. So all of these clauses, with the exception of the Pennsylvania clause, which does have an individual right, all of these other clauses he's using are not about individual rights. They are about the state militias. Now, you might not like this, and that's okay, because there are lots of things in the 1787 Constitution I don't like. I don't like the Electoral College, which was put there so that the slaves of the South could give the southern states more presidential electors. I don't like the fact that Thomas Jefferson got to be president because electors created by counting slaves put him over the top over John Adams. But that's the system we have. And if we're going to interpret it, we have to at least play fair and be honest. One of the interesting things he does is to talk about the Virginia Constitution, the Virginia Bill of Rights. And he notes that Thomas Jefferson, so he claims, and I do not have time to go in this in great detail, although it will be in a printed version of this. He claims that Thomas Jefferson is in favor of an individual rights to own weapons. And then he says that the Virginia legislature, which is writing the Virginia Bill of Rights, substitutes George Mason's proposal for Jefferson's. The only problem is this. Jefferson is not in the Virginia legislature. Mason is. The Virginia legislature had adopted Mason's proposals, and then Jefferson, arrogantly, not being a member of the legislature, sent the legislature his list of amendments to a Declaration of Rights, which the Virginia legislature completely ignored. So Scalia actually has the chronology backwards. It's not that the legislature substitutes Mason's language for Jefferson's. It's rather that they buy Mason's language and then they ignore Jefferson's. Again, if you're going to do history, there's a key point to doing history that's really important. You actually have to get your chronology right. You can't say A proves C and then turn around and say D proves A when D came after A. You can't do that. You have to go in order. Scalia doesn't do that. Scalia, in other words, plays fast and loose with history throughout the opinion. I could give you many other examples of this, but we are limited to time. And I think he does this really because he is contemptuous of history. And what's really interesting about Heller is that it fits very well with other decisions that were contemptuous of history. The most obvious is Dred Scott, where Chief Justice Taney completely rewrites American history to say that blacks were never citizens of the United States, even though free blacks could vote in 6 states in 1787, including North Carolina, and free blacks continue to vote in North Carolina into the 1830s. But somehow Justice Taney says, oh, well, they've never been citizens. Well, you wonder, how could they be voting for members of the House of Representatives? How can they be voting for the state legislature that chooses senators? How can they be voting for presidential electors if they aren't citizens? But he completely rewrites history to get to where he wants to go. And it strikes me that the Heller opinion is very much like that opinion. I want to end in a slightly different way, because I think this is symptomatic of Scalia's jurisprudence. When not on the bench, but when writing a book called A Matter of Interpretation, Federal Courts and the Law, Justice Scalia defends his Second Amendment views. And he defends them by saying he is supported not by some member of the NRA, but rather, he writes, the biggest supporter of him is not a member of the Michigan militia, but an Englishwoman who has written a great book about bearing arms. And he says that this Englishwoman teaches at an English college, Bentley College, which must be somewhere in Cambridge or Oxford. And I'm going to ask Joyce, where were you born?
I'm an American. Upstate New York.
Utica.
Yeah.
We're neighbors.
He
Is
got
Bentley
that one
College
wrong.
in England?
No,
Okay.
I don't teach there anymore.
He's citing Joyce Malcolm. Welcome. Did you fly over from Britain today? Now the point is this. Justice Scalia has the brightest people on earth as his clerks. He has a whole army of librarians to find out that Joyce Malcolm is at Bentley College in Boston, not in England, and that she was born in Utica, New York. He could have called the National Archives and said, you know, check.
It was not a big point with him, I'm sure.
No.
It was no judicial opinion.
Okay, all right. It is not a big
when
point with him.
He was actually praising my book, for which I was very pleased.
Could I finish my talk now? Thank you.
Well, you referred to me. I felt I could get in.
I'm not beating up on you. It's
No,
not
I
about
realize that.
you. It is about a Supreme Court justice that wants to make a very snarky point. She's not a member of the Michigan militia. She's an Englishwoman. And this shows somebody who is uninterested in facts and uninterested in accuracy and likes to say whatever comes to mind that he thinks will support his opinion. And I would argue that that is the essence of the Heller opinion. And it's an opinion that ought to be put in the dustbin of history, because almost all of the history in Heller is simply flat out wrong. Thank you.